Thank you. Be seated, please. All right, ladies and gentlemen, remind you to turn off your cell phones or any other electronic devices you may have. Now, before we begin, I'm going to instruct you on a certain matter. Jury service may be strange to you, so a short explanation is ordered. Those who participate in a trial must do so in accordance with established rules. That's true of the witnesses, lawyers, the judge, and jurors. Lawyers present the evidence according to the rules. The judge enforces those rules and determines what evidence may or may not be admitted. Now, as a jury, you will be the sole judges of the facts, credibility of the witnesses, the weight to be given to the testimony. And at the end of the trial, the court will instruct you regarding the law on those matters, and you'll apply that to the facts. Now, it is your sworn duty as jurors to accept the law as it is given to you by the court. Procedure for the trial will be as follows. First, the attorneys will outline what they expect the evidence will be. Excuse me. These are called opening statements. Opening statements are not evidence. They are simply a preview of the claims of each party designed to help you follow the evidence as it is presented. Then, the state will offer evidence. At the conclusion of the state's evidence, the defendant may, but is not required to offer evidence. If the defendant does present evidence, then the state may, but is not required to present rebuttal evidence. The trial then will conclude with instructions of the law by the court, the arguments of counsel, deliberation instructions, and then after that you'll retire to reach a verdict. Now, procedure for questioning witnesses are as follows. The party that calls the witnesses will ask that witness questions first. That's called the direct examination. The party that, the opposing party then may ask questions, that's called cross-examination. And then, after cross-examination, the party that called the witness may ask questions about what was inquired to on cross-examination. That's called redirect examination. The jurors will not be permitted to ask questions. Now, during the trial, it's likely attorneys will make objections. This is the procedure by which attorneys raise legal issues that are to be decided by the judge. Now, I don't just make these up as I go or decide what I think is fair. I apply the rules of evidence that have been prescribed by the High Supreme Court, as well as the statutes in the state of Ohio, and other legal rules that govern admissibility of evidence. If an attorney objects, then the court has to determine whether that question and or answer are permitted under the rules. If I say sustained, that means I've determined the question and or answer is not proper under the rules and cannot come into evidence. If I say overruled, that means I've determined that both the question and the answer are proper, and you will hear that evidence. Now, because people sometimes tend to talk over each other, occasionally it's, well, maybe not even occasionally, but usually during a trial, a witness may answer a question that's objected to before the objection is out or before the court has an opportunity to rule. And if I determine at that point that the answer that was given or the question and the answer are impermissible, then I will sustain the objection, and that means that you'll have to disregard that testimony, which I'll explain later at the end of the trial. Or a party may say move to strike, in which case I'll say, you know, that testimony is stricken, which means basically that you'll not be able to consider those items in your deliberations. Now, you must be fair and attentive through the trial, but you are not to discuss the evidence or the case in any way among yourselves or with anyone else during the trial. If you're a person who tends to text or tweet or do other social media, do not post anything to social media about your service on this jury until it's concluded and you've been discharged. During the breaks, you're not to talk with anyone about the matter or permit anyone to talk about it. And that includes even among each other. So if you're during a break, if you're in the jury room, you're not to discuss it among each other. If you're out during breaks, you're not to discuss it with each other. You are not to make any decision or express any opinion on this case whatsoever until the conclusion of the case. Because until you've had the final submission of the case based on the evidence and the law and the closing arguments of counsel, you do not have everything that you need in order to render a verdict. Now, you're not to talk with attorneys, any of the parties, witnesses during the trial, and likewise, they're not to talk with you other than, say excuse me or thank you or something like that, but there's not to be any discussion between you and them. And you're not permitted to allow anyone else to talk about it in your presence or to say something that you might overhear. If people are talking about the trial, tell them that you're a juror and you are not to hear anything like that. Ask them not to speak or move away from that conversation. You're not to investigate or attempt to investigate to obtain any additional information about this matter outside of the courtroom. It's highly improper for you to do that. And again, this case is to be decided based on what comes into the evidence from the witness stand through exhibits. So if you hear something, a topic, sometimes it might come to the trial and you think, well, that's interesting, or I'd like to know more about it, or I've never heard that before, I think I want to check that out on the internet. Don't do that, not until after the trial is complete. Now, you're not to read, view, or listen to any report in any form of media, being newspaper, radio, television, internet, social media, those type of things, while you're serving during this trial. Don't permit anyone to read or comment about them to you in your presence, and again, you're not to post anything about your service on this jury in any kind of social media until completion of the case. Because again, you have to decide this case based only on the evidence that's received in the courtroom. And if you were to acquire information from outside, that would not be permissible. Now, in the event that something happens, you hear something or someone says something to you, or you think there's something that's come up that you should bring to the court's attention, inform the bailiff, and then the bailiff will report to me, and then I'll confer with the attorneys to determine what might need to be done. Occasionally, we have to ask you questions about what happened or what the information was or whatever the incident was, determine what effect that may have on your continuing to serve. Now, if something like that happens and you're not certain what to do, report it. Don't seek the advice of the other jurors. And the reason for that is this. If you come back from lunch, say, or a break, and you're back there in the room with your fellow jurors, and there are 14 of you, and you say, well, this is what happened, I'm not sure, I guess I should report it, but I wasn't sure, and, then everybody says, yeah, well, you should report it. Well, the problem is that now, instead of just talking to you, I have to talk to all 14 of you. And I had a case when I was prosecutor years ago. We had, it was a week-long trial. We had 12 jurors and 3 alternates. That happened, and we spent an afternoon talking to 15 jurors, asking them questions, and so we lost a whole afternoon of trial time. So that's why I say, don't discuss something like that with anyone else. Now, this will be just a short trial, one-day trial in terms of evidence, and so the court doesn't permit any note-taking during that period of time. From time to time, you will see that, as we already have it, we'll have a bench conference where the attorneys come up to the court, to the bench. We put on the white noise, and that is so to discuss, sometimes it's an evidentiary issue, and in order to make sure that we don't have to tell you to disregard something or not consider something, I'll hear the arguments and what that expected answer might be to determine if it's admissible. And if I say it's not admissible, then that means you didn't hear any of that. We don't have to ask you to disregard more information. Sometimes we discuss logistical issues or other legal issues that need to be discussed outside your presence. So with that, we will now proceed with the trial. The first stage will be the opening statements of counsel, which are not evidence but are simply their indication of what they expect the evidence will show. So the state will go first. Ms. Collins, on behalf of the state.
May it please the court, Mr. Stetina. Ladies and gentlemen of the jury, today the state will prove beyond a reasonable doubt that on December 21st of 22, Daniel Miller, this defendant, caused serious physical harm to Lonnie Klauser. The state will walk you through the evening hours of December 21st of 22, when Dorothy Leith was bartending at the Eagles in Greenfield in Highland County, Ohio. Lonnie Klauser, a regular member at the Eagles, came in and he had a shot of alcohol with Keith Jackman. Then the two of them left. Lonnie returned later in the evening, took a seat at the bar, and began drinking. Also at the bar that evening was Laura Derbyshire, Amanda Bainter, Willie Hiley, and Ronald Anderson, and Ron's girlfriend, Deborah Lyons. Finally, also at the bar was the defendant. At some point, Dorothy decided that Lonnie and Willie had had enough to drink. Lonnie and Willie were getting loud. She cut him off. Lonnie went to the bathroom. Everything was fine. But when he returned from the bathroom, he tried to order another beer. Dorothy reminded him, "Hey, I cut you off." Lonnie became angry at this point, and he cussed at Dorothy. Willie intervened. He told Lonnie, "Hey, calm down." Now, at this point, no one in the bar had been physical with one another. There was no fight, no one putting hands on anyone else at the bar, no threat of harm to anyone. In fact, as the video will clearly show, Lonnie had his hands in the air in an obvious, I don't want any trouble kind of stance. This defendant changed all of that. This defendant got in Lonnie's face and then pushed him hard into the bar stools, causing Lonnie to fall to the floor. The first person to make this evening physical was this defendant, Daniel Miller. When Lonnie got back to his feet, Willie and Amanda, Willie Hiley and Amanda Bainter, got in front of Lonnie in an attempt to de-escalate the situation. But Lonnie was understandably upset. He'd just been assaulted by the defendant, and while Willie tried to calm him down, Lonnie pushed Willie, causing Willie to fall. Now, Willie was not injured, didn't need any sort of medical treatment. In fact, he gets right back up, and he goes right back to Lonnie and tries to intervene again. But this little bit of ruckus caused several other people to go to that end of the bar. Ronald Anderson was one of those people, and he shoved Lonnie hard and was clearly getting the best of Lonnie, who is obviously unable to keep his balance. Now, this defendant has no reason to get involved again. No reason. But he just can't help himself. And when Lonnie has his back to the defendant, this defendant attacks Lonnie, hitting him first in the back of the head. This caused Lonnie to fall into a jukebox, and as he fell, this defendant grabs Lonnie by the arms and slams him hard onto the floor. Lonnie cracked his head on the floor. He was immediately unconscious and bleeding from his head and ears. This is not enough for the defendant, though. He crosses the bar and strikes Lonnie in the face again. Now, Dorothy, the bartender, intervenes, and she yells at the defendant, and she calls 911. Now, when officers arrived, paramedics tended to Lonnie, who remained unconscious. Lonnie was transported to the Adena Medical Center in Greenfield and then flown out to Grant Medical Center. And it was found that Lonnie suffered a skull fracture and 3 brain bleeds. He was in the hospital for a couple days to ensure that he didn't die from the injury. He returned to the hospital a few days later because of headaches and sickness. Today, he still suffers the effect of this assault, of this injury with seizures and memory loss, and he has only recently been released to drive short distances. Now, meanwhile, back at the Eagles, while Lonnie was being treated and hospitalized, Scott Bentley arrives at the Eagles. He was president at the Eagles, and he had access to the video cameras. Scott began to view the video. While he's doing that, Patrolman Mark Hamilton interviewed witnesses, other people in the bar, and specifically spoke to the defendant. The defendant told Patrolman Hamilton that he had seen the altercation but was no way involved. However, the video evidence shows a very different story. You will hear about all of this from witnesses who were at the bar, the medical professionals who treated Lonnie, and Lonnie himself. You will see the video of the bar that night, and you will see for yourselves what transpired. You will hear that Lonnie had too much to drink. He got loud. He was obnoxious. He was asked to leave. What you will not hear is that Lonnie threatened anyone in the bar. You will not hear that anyone was in serious physical danger from Lonnie. In fact, you will not hear that anyone needed protection from Lonnie. You will see that this defendant was the very first person to put hands on Lonnie. This defendant pushes him first. You will hear and see that when this defendant came up behind Lonnie, Lonnie was not a threat to anyone. In fact, Lonnie was being assaulted by Ronnie Anderson when this defendant walks up, grabs him, and slams him to the floor. At the conclusion of this trial, after you hear from the witnesses and you review the evidence, I'm confident that you will find this defendant guilty of felonious assault for causing serious physical harm to Lonnie Klauser on December 21st, 2022. Thank you.
All right, thank you. Mr. Cettino, on behalf of the defendant.
Thank you, Your Honor. May it please the court, Ms. Collins, ladies and gentlemen of the jury. This is opening statement, and it is a preview of what I believe the evidence will show in this case. Now, you just heard Ms. Collins' statement of what she believes the evidence will show. What we believe the evidence will show is that on December 21st, 2022, Dan Miller was a patron at the Fraternal Order of Eagles, number 1325 in Greenfield, Ohio. The time was after 11 p.m. and the bar was winding down. Present at the Eagles were Mr. Miller, Lonnie Klauser, who you will see is a large man, approximately 250 pounds, and a former Marine. Dorothy Leith, the bartender, who was subject to Mr. Klauser's repeated verbal abuse, including expletives that I won't repeat in this courtroom. Willie Hiley, an elderly patron at the Eagles, that by Mr. Klauser's own admission is about 100 pounds less than he is. Amanda Bainter, Laura Derbyshire, Deborah Lyons, and Ronald Anderson, the person that was involved in the fight with Lonnie Klauser after aiding Willie Hiley, who was thrown into a row of chairs. The evidence will show, and you will see, we have the benefit of a security camera, that Lonnie Klauser was seated at the bar with Dan Miller. You'll see his arm around Lonnie Klauser. And you're going to hear a lot about how Dan Miller somehow held a grudge against Lonnie Klauser about some words they had some months ago. And this apparently was the whole basis for Dan Miller doing what he did. Lonnie Klauser was highly intoxicated and demanding more alcohol after having consumed numerous alcoholic beverages in several locations throughout Greenfield. Lonnie was verbally and physically abusive to the bartender, Dorothy Leith, and others, using foul language directed at Dorothy for not serving him, repeatedly calling her a word that begins with B, and to serve him an effing drink. Dorothy Leith made the extraordinary move to call the Eagles president, Scott Bentley, who you will see testify, to report what was happening, and that his friend and fellow Marine veteran was out of control and that she needed assistance. Lonnie Klauser was shut off and was ordered to leave, but didn't. He refused to leave. Willie, again, we have Willie and Lonnie and Dan sitting at the bar. And at some point, you'll see Lonnie Klauser was upset with Willie because Willie was standing up for Dorothy, the bartender, saying, hey, cut it out. You'll see Lonnie Klauser and Dan Miller step in front of Lonnie, between Lonnie and Willie. Willie, the older, much smaller man. Lonnie Clauser threatened Dan Miller for getting involved and got in Dan Miller's face, screaming more expletives for all to hear. With his hands raised in a threatening manner, the state is characterizing that as something not as threatening, or in some manner of surrender, I don't know. But you'll make the determination, and we submit what the evidence will show is that Lonnie Clauser was threatening Willie highly, and Dan Miller stood up to him. And at the moment that Lonnie Clauser raised his hands and yelled at him, Dan Miller pushed him away from him. And Lonnie Clauser, being so drunk, fell on the floor like a big bag of potatoes. Well, of course, Lonnie wasn't happy about that, and things escalated from there. All of the witnesses that I've previously mentioned to you now come out onto the floor and are keeping Lonnie Clauser from getting to Dan Miller. At some point, Willie Hiley is thrown into the row of chairs by Lonnie Clauser. And at some point, Deborah Lyons is too close to Lonnie Clauser, Deborah Lyons being the girlfriend of Ronnie Anderson. And the evidence will show Mr. Anderson then injected himself into the situation, and a full-on fight began between Mr. Anderson and Mr. Clauser. Contrary to what the state believes, you will see is that Mr. Anderson began assaulting Mr. Clauser. Dan Miller stood up again, the evidence will show, and fearing bodily harm to Ronnie and people in his immediate vicinity, put Lonnie down on the floor where he couldn't threaten or bully anyone anymore. These are the facts as the defense believes the evidence will show. And remember that the state bears the entire burden of proof in this case. The state must prove each and every element of felonious assault, and that is cause or attempt to cause serious physical harm to another. And by proof beyond a reasonable doubt, the state must prove that Dan Miller was not acting in the defense of others. This case is about the affirmative defense of others. The evidence will show that Dan Miller had reasonable grounds to believe and held an honest belief that Ronnie Anderson and others were going to suffer physical harm because of Lonnie Clauser, who repeatedly refused to leave the bar. The evidence will show that it was Lonnie Clauser, through his drunkenness and abuse, that started the sequence of events that ended in his injuries. That Ronnie Anderson was not at fault in creating the situation, giving rise to the defendant's use of force. And that Dan Miller's actions were reasonable, and that he did not use more force than was reasonably necessary, and certainly not greatly disproportionate to the apparent danger. This case is not about some revenge about two men, but simply one man getting out of control and being stopped by two other men, Dan Miller and Ronnie Anderson, who had seen enough and decided to do something. Were Dan Miller's actions perfect, you'll see? No. But he did something. It was Lonnie Clauser who decided to go drinking all over town, come back, start bullying people, and refuse to leave. It was Lonnie Clauser that was highly intoxicated, aggressive, belligerent, and a bully to weaker, smaller people than himself. Until this man did something about it. Until Ronnie Anderson did something about it. And I am confident that after you have seen all of the evidence, you will be firmly convinced that Daniel Miller is not guilty of felonious assault, and that he acted in the defense of others. Thank you.
Thank you. Your first witness.
Scott Bentley.
Is there a motion for separation of witnesses?
Yes, Your Honor. I don't think we have.
They're not in here.
They're not in here.
Okay, but I mean, all right, I'll go ahead and order the witnesses to be excluded, other than the state's representative was the defendant, if he should decide to testify. Oh, and ladies and gentlemen, if we have some air conditioning on, it can cause a little background noise, but if you have any trouble hearing, speak up and tell us, or make, and then I'll instruct. I'll try to keep the witness, keep them speaking up, because I don't hear as well as I used to either. So, but if you have any difficulty, let me know. All right, Mr. Bentley. Were you sworn in the clerk's office? All right, just have a seat over here, please, and make sure your cell phone's off. And pull that microphone over completely, and please speak loudly and clearly into the mic. All right, you may inquire, Mrs. Collins.
Please state your name for the record.
Scotty Lee Bentley,
And can you spell your last name for us?
Bentley.
And are you familiar with the Eagles in Greenfield?
I am.
What is the Eagles?
A non-profit charity organization. We have a brotherhood or a fellowship, and we donate to several charities, make scholarship funds and things like that.
How long have you been a member of the Eagles?
7, 8 years now.
Are you currently the president of the Eagles in
I am.
Greenfield?
Yes.
And what does that job entail?
I kind of oversee all the ongoings of the place, you know, make sure smooth operations, make sure my trustees and the other officers I have involved are doing their jobs, and, you know, kind of just oversee daily operations, I guess it's called.
And were you the president on December 21st of 22?
I was.
Are you familiar with Lonnie Klauser?
Yes.
And how are you familiar with him?
I've known him since we were kids, but yeah, he's also a member of the club. So.
And you and Lonnie have something in common other than growing up together?
Yeah, we're both Marines. Yeah.
Are you familiar with Dorothy Leith?
Yes.
And how are you familiar with Dorothy?
I've known her since, we were children too. So, I mean, she's best friends with my sisters, and she was also one of my employees at the Eagles. She's a bartender there.
She was a bartender at the Eagles?
Correct.
Are you familiar with Laura Derbyshire?
Yes.
And how are you familiar with her?
She was a cook / cleaner there at the club. So.
What about Willie Hiley?
Yeah, he's also a member. He's a member of the club. He's been a long time member.
What about the defendant, Dan Miller? Are you familiar with him?
Yes, absolutely.
And how are you familiar with
Oh,
him?
he's a club member.
And
We socialized before. Yep.
Do you see Dan Miller in the courtroom today?
Yeah, I do. He's in a blue shirt.
Please let the record reflect the witness has identified the defendant.
So ordered.
Now, going back to December 21st, did you receive a phone call to respond to the Eagles?
Yes.
What was the nature of the call?
Bartender was telling me there was some patrons about, having words with each other and maybe some trouble. So.
Did you go into the
I
Eagles?
did.
Now, what did you find when you arrived there?
Mr. Klauser was on the floor in a puddle of blood surrounding his head. Looked like he had fallen or something, some type of head injury anyway.
Did you speak with Patrolman Hamilton when you arrived?
I'm sorry.
Did you speak with Patrolman Hamilton when you arrived? Mark Hamilton, the officer?
Eventually. I arrived before but yeah.
And did he ask you to do something?
He asked me to review footage if we had security cameras and such, and I did.
And you did have video cameras?
We did, yes.
And did you review the footage of what happened?
I did.
Now, based on what you saw on the screen, what did you do?
I paused the video immediately and went and got the officer. I was instructed if we seen anything that was like a blatant assault or anything, because I didn't even know at the time what was going on. So once I seen the video, I paused it and went and got the officer to come and review it.
Was there a copy of the video made?
Yes.
May I approach the witness?
May.
I'm going to hand you what's previously been marked as State's Exhibit 1 for identification purposes.
Right.
Do you recognize this?
I do.
And is this the video of what you saw on December 21st of 22?
Yeah, it appears to be the CD of it, yeah. or
Is
video.
a true and accurate depiction of the video?
Yes, yes.
At this time, we would ask to admit State's Exhibit 1 into evidence same for the jury?
Mr. Sedina?
No objection.
Admitted without objection. You may do so.
Now, wait, listen, Mr. Bentley, are you able to identify everyone that we're going to see on this video?
Yes.
So as soon as it starts playing, I'm going to ask Mr. King to pause it and have you approach the screen and identify for us who is in the video.
Okay.
I wonder if Mr. King can move back this way to get away from the screen so the jury can see it clearly. Or,
If he moves
Or you
that
can-
way, it will unplug stuff.
okay, can you move the monitor that way? Dan, can you see about moving this monitor over? Yeah, that should be good. Yeah, thank you.
Okay. Okay, go ahead and pause. Mr. Bentley, if you can approach the screen.
Yes, I can see.
Yeah, you will need to go down there, Mr.
You
Bentley.
can cut here.
Oh,
Yeah. Stand on the other side there so you will, so the jury will be able to see. There you go.
Who is
Thank you.
in the brown jacket there?
Willie.
Willie Miley?
Yeah.
And the blue shirt?
Lonnie Clauser,
And the gray sweatshirt?
the defendant.
Okay, okay. And who is behind the bar there?
That's Dorothy, Leith.
Okay. Do you know who arrives here in the black shirt?
I always have trouble remembering her name, to be quite honest with you, but yeah, I am familiar with her being a club member, though.
Who is the lady there in the black sweatshirt that's standing by the bar?
Her name is Debbie. She's one of our employees.
Is the other lady here Amanda?
Yes, Amanda. Yeah.
Okay. And who is that?
That's Ronnie Anderson.
Okay. A new person is just coming in the top of the screen by the door. Do you know who that is?
Yeah, it's Laura Derbyshire.
Okay. Okay. Thank you. Mr. Bentley, have you had occasion to speak with Mr. Miller since that night?
I'm sorry, I didn't hear you on that.
Have you had occasion to speak with Mr. Miller, the defendant, since that night? Have you spoken with him?
Oh, yeah, I've seen him at the club, yeah.
Has he ever told you that he was defending anyone at the Eagles that night?
We never discussed the case.
Prior to December 21st of 22, had you ever heard the defendant threaten Lonnie Klauser?
Yeah.
Can you tell us about that?
We were all at the bar that night, one on either side of me. And it was a banter back and forth, kind of picking on each other a little bit, I guess you call it. And, you know, I don't know the exact words of what he said, but it was a threatening demeanor, and at the time it was just, it seemed like it was fun until it just wasn't fun anymore.
Do you know about how long before the night in question, before December 21st, did that happen?
I'd guess 3 months approximately, 2-3 months.
Okay. And what did you do that night, if you can remember?
Oh, I cut it off. I mean, I just told them both to shut up, basically. I mean, it was over.
No further questions.
Cross?
Thank you, Your Honor. Good morning, Mr. Bentley.
Morning.
Mr. Bentley, you testified that you and Lonnie Klauser are friends? You and Lonnie Klauser are friends?
I've known him since childhood, but not a close friend, no.
Oh,
But,
okay. So how would you characterize your acquaintances, or?
yeah, about similar acquaintances. Yeah.
All right, so you don't hang out?
Right, no.
Okay.
No.
And when was the last time you saw Mr. Klauser?
I mean, other than today, I couldn't
Other
tell
than
you last
today.
time, yeah. It's been
Can you remember?
months, maybe.
It's been months?
Since the last time I was here, I would guess would be, yeah.
And who's Dorothy Leith?
She was a bartender on duty that evening.
Is she a bartender there now?
She's no longer an employee there.
When did she quit?
Within the last month or so.
Did she give a reason for quitting?
Objection, relevance.
Sustained.
How do you know? You know her because she's a bartender. Do you know her outside of the Eagles?
I knew her from when she was a child and hung out with my younger sisters.
Okay.
Aside from that, I don't associate with her outside of the club.
Now, you testified that on the night of December 21st, 2022, you received a call from
Correct.
Dorothy Leith.
Yes,
And you received a call from the Eagles Club, correct?
yes,
And that call was about Lonnie Klauser, and she couldn't get him to leave, correct?
right,
And that she had cut him off.
yes.
Was that unusual for you to receive a call from Dorothy about needing assistance with an unruly
Yeah,
patron?
it was out of ordinary, yes.
Has that ever happened before?
I've gotten calls before, only because I didn't have trustees, which my trustees are supposed to handle the bar in that area. But at the time, I only had one, and he wasn't available, so the call came to me that evening. Yeah.
Do you remember what time it was?
I don't recall. It was late in the evening.
After midnight?
No, not quite. I would say 9 o'clock in that time frame, probably.
Okay. Now, you had testified about a prior incident between Mr. Miller and Mr. Klauser at the Eagles
Right.
Club, correct?
Yeah.
And you described it as banter
Right.
between the two of them?
Yes.
Was one giving the other as good as the other?
Exactly. Yeah. It was back and forth.
So,
Yeah.
when you said that Mr. Miller had made a threat to Mr. Klauser,
Right.
was that an overstatement or?
No, I think it got to the point where, like, it was no longer a consensual conversation, I guess I would say it was at that point. Like, he was tired of it. He was done with it, you know.
But you don't recall any particular verbiage used, any words that
No, it's been so-
constituted a threat?
Right. It's been so long, I don't even know exactly what was said, but
So it could have been that Mr. Klauser was also threatening Mr. Miller?
I'm still having trouble hearing. I'm sorry.
You said it was a back and forth. Were they
Right.
threatening each other?
There weren't threats back and forth. It was basically men locker. I'd say exactly. It was like each other calling each other fags or whatever. Just
Insults.
right back and forth. Yeah.
So Mr. Miller didn't physically threaten Mr. Klauser at that.
Oh, at the end, he did. Yeah.
And what exactly was that physical threat?
Just basically like threatening to kick his ass or whatever.
Okay, so he said, "I'll kick your ass."
Right. Right.
Did
I
Mr.
don't know
Klauser-
exactly
did
the
Mr. Klauser
verbiage.
say that as well?
Not at the time. No.
So he said it another time?
Objection to what Mr. Klauser said another time.
Sustain.
You just watched the video here. Were you surprised to see Mr. Miller and Mr. Klauser sitting at the bar together and Mr. Miller's arm around Mr. Klauser?
No, didn't
Not
surprise
you?
me to see that. No,
Why not?
it just seemed like it was normal.
Okay, so they weren't enemies.
Right.
There was
Yeah.
no, you know them both. There was no bad blood between them.
Objection. This calls for speculation. He doesn't know what they're thinking.
Your Honor, I think
Sustain.
you know them well, and that doesn't surprise you.
That didn't surprise me that they would hang out with each other. No,
Thank you.
Right, yeah.
No further questions.
absolutely.
Redirect.
You mentioned that you have trustees that are supposed to handle calls. So if other calls had come in, those calls would have gone to your trustees.
Correct. Yeah.
So what was, is it true, basically what was odd was that you.
Objection leading.
Was it odd
Wait a
that
minute.
you got the
Wait a
call?
minute. I'm going to sustain the objection, rephrase it.
Was it odd that you got the call that night?
Yes.
Was it odd that a trustee didn't get the call?
No.
Thank you.
Yeah.
All right, thank you, Mr. Bentley. You may step down. Your next witness?
Dorothy Leith?
Did you get sworn in the clerk's office?
Yes.
All right, just have a seat there, please.
Please state your name.
pull that microphone over in front of you and make sure you keep your voice up, speak into it. Keep, pull it on over.
Pull it up.
There you go. All right.
Dorothy Leith,
Can you spell your last name?
Leeth.
Have you watched any of this trial today on YouTube?
No.
Are you familiar with the Eagles in Greenfield?
Yes.
And what is the Eagles?
It's a private club that I bartended at.
So you used to be a bartender there?
Yes.
And were you working there on December 21st of 22?
Yes.
Do you recall about what time you arrived?
3.
Are you familiar with Lonnie Klauser?
Yes.
Are you familiar with Daniel Miller?
Yes.
Do you recall Lonnie Klauser being in the Eagles on December 21st of 22?
Yes.
Do you know, can you tell us about, when he came in, anything like that?
He came in shortly after I was there the first time, had a beer. He left. He came back a few hours later with Keith Jackman. They had a beer, they had a shot, they left. And then a couple hours later, hour later, Lonnie comes back alone.
Do you recall Daniel Miller being in the Eagles on December 21st?
Yes.
Do you see Daniel Miller in the courtroom today?
Yes.
Can you please point him out for the court?
There.
Please let the record reflect the witness identify the defendant.
So ordered.
Do you recall who arrived at the last time when Daniel came? Who arrived first, Lonnie or Daniel?
Lonnie was there Daniel was there when Lonnie came back the third time.
Do you know who Willie is?
Yes.
Who is he?
He's a patron there also.
At some point, did you decide that Lonnie and Willie had enough to drink?
Yes.
What was their initial response to you cutting them both off?
Neither one of them said anything.
What did Lonnie do then?
They were all down on the right side of the bar when I cut them off. And then Dan and Amanda went down to the left side of the bar. And then Lonnie followed them down there. And Lonnie went to the bathroom. And when he came back from the bathroom, I asked him to pay his tab. And he said, maybe I'm not done drinking yet. I said, we already discussed this. I'm not serving you anymore. And that's when he looked at me and said, you're a bitch. And I said, it's time for you to leave. You need to leave. And he said, you're not even a good bartender. The only reason why you're even here is because they can't find anyone else. And when I had asked him to leave and he said that, I went back to the kitchen and I called the president, Scott.
Now, as that was happening, what happened in the bar?
From the video, I personally didn't see it, but from the video, Dan had came and got up out of his seat and come over to Lonnie and put his arm around him, and I don't know what was said. I wasn't up there. And then Lonnie got up out of his seat, and Dan shoved Lonnie, and Lonnie got back up. Then by this time, everybody was all around, and then
Let me ask a question. Did you see where Willie got pushed?
Yeah.
Did Willie require any kind of medical assistance?
No.
Did anyone have to help Willie back up or over where? Did you have to help?
No, I went around the bar, and by that time he was up, but then I was like, oh man, like I need to get back behind my bar. I didn't want to get injured.
Did you see when Ron Anderson came down to where Lonnie was?
Yeah, and when I went back behind my bar, I called maybe I was on the phone with Scott. Now, Ronnie, when Hailey got pushed down, that's when Ronnie came, because everybody was there. Debbie was in the mix of it, and Ronnie came, and there was a lot of shoving going around. Then after that, Dan shoved Lonnie, and when he shoved Lonnie, he fell and his head cracked the concrete.
Did you hear his head hit the concrete?
Oh yeah.
What did that sound like?
It was the worst sound I ever heard. It was like a baseball bat hitting times 20, times 10. It was it was an awful noise.
After, was Lonnie on the floor at that point?
Yes,
What did you see the defendant do after that?
he slapped him,
What was Lonnie doing?
snoring.
Were you concerned about Lonnie?
Yes, that's when I called 911.
Did you see blood?
Yeah, he had blood out of his ears.
Did you say anything to the defendant?
I told him to get away from him, get off of him.
Now, I want to go clear back to when you cut Lonnie off. At any point did Lonnie lunge at you or attempt to hit you or anything like that?
Nope,
At any point did he threaten to physically assault you?
nope,
Physical harm?
no.
No further questions.
Ross?
Good morning, please. You testified that you cut Lonnie Clauser off, correct?
Yes.
And how long had you been a bartender at that point?
About a year and a half.
In total, everywhere or just at the Eagles?
Everywhere.
Okay. And had you cut people off before?
Yes,
At the Eagles or other places?
yes.
Okay. And what exactly was it that Lonnie Clauser was doing that made you finally cut him off?
Him and Willie were arguing with each other, and Lonnie also kept putting his hands on Amanda, like groping her. I didn't see it, but what she was saying was,
Well, objection to what she said. If she didn't see it, that's speculation.
but I heard what she was saying.
Wait, okay. I'll sustain that. If you didn't hear something, you can't repeat it.
Continue.
So she was telling him to get his hands off of her.
Yeah.
Quit touching
I'm
her.
going to object. Didn't you just sustain this?
Okay.
I don't know.
Who was saying this?
Amanda, and I heard her
Wait a minute,
say
I
it.
can't understand. What? Okay, I'm having trouble understanding you. Who are you quoting as saying something?
Amanda was saying it to Lonnie.
All right. Okay. I'm going to overrule that.
Is that what made you say enough is enough?
Yeah. Yes.
Would you describe Lonnie Clauser as being loud when he was calling you these expletives?
Yes.
And did that make you feel, how did that make you feel?
I was angry. I told him to leave. He wouldn't leave. I felt like I didn't have any control in my bar.
How many times do you think you told him to leave?
I told him one time to leave, and I called the president.
How long did it take Mr. Bentley to get there?
Too long. I honestly don't. It was, I should have called the cops.
Why?
They could have got there quicker.
What would have made you call the police?
He wouldn't leave. He wouldn't leave. I thought calling Scott could get him to come in and get him to leave. And I didn't want to involve the police out there, but I should have called the police and we wouldn't be here today.
No further questions, Your Honor.
Redirect.
You cut Willie Hiley off as well, correct?
Correct.
And was that for being loud?
Loud and arguing.
No further questions.
All right, you may step down. Thank you. Next witness.
Your Honor, I am going to call Dr. Stiltner at this time.
All right.
It's getting close to the lunch hour, so.
Were you sworn in the clerk's office?
Yes.
All right, if you would have a seat over there. If you have a cell phone, make sure it's turned off.
I did.
All right, and please keep your voice up and speak into the mic there. You may inquire.
Please state your name for the record.
Dr. Sean Stiltner,
And can you spell your last name?
Stiltner.
And Dr. Stiltner, have you watched any of the trial this morning on YouTube?
No, I have not.
Are you currently employed?
I am.
Where are you employed?
I work for Provectus. It's a long-term care facility. I used to work for Adina in the emergency department, though.
Was that Greenfield?
It was
How long were you employed there?
about 3 years.
And what sort of education do you have?
I am a doctor of osteopathy, so a DO degree, which is a degree in medicine.
And were you employed at Adina in the emergency department on December 21st of 22?
I was.
And did you have occasion to treat a Lonnie Clauser on that evening?
I did.
And how did Mr. Clauser arrive at the emergency department?
By ambulance.
May I approach the witness?
You may.
I'm going to hand you what's previously been marked as State's Exhibit 2 for identification purposes. Do you recognize that?
I do.
And what is that?
This is the records from the visit that Mr. Clauser had in our emergency department.
And is that top page a certification that those are true and accurate records?
It is.
And have you had the opportunity to review those records?
I have.
Now, are you the attending and treating physician that's listed in those records?
I am.
I'm going to refer you, or if you just know without looking, but when Mr. Clauser arrived in the emergency department, what was his appearance?
He was very confused and a little bit on the belligerent side just because he was confused, didn't know what was going on. He was appeared somewhat intoxicated.
Did you notice any visible injuries? Could you tell of injuries?
Yes, he had some bleeding from his ear, and he was, I'd have to look at the records to recall the rest, but he did have some injuries, yes.
Now, what sort of test, based on what you observed in scans, did you order for Mr. Clauser?
I believe the records show that I ordered a CAT scan of his head and his neck. CAT scan is a X-ray type device that gives very precise readings. And then I also ordered some laboratory values.
And were you provided with the results of the CAT scan?
I was.
I'm going to refer you to page 4 of 6, and I have marked it there. What were the findings of the CAT scan?
It says impression, motion artifact limiting the exam, non-depressed linear skull fracture along the left occipital region extending into the left temporoparietal region inferiorly and into the temporal bone. Laterally with a small 2 to 3 millimeter acute subdural hematoma along with parietal region extending inferiorly along the temporal lobe. There's no significant mass effect or midline shift.
Okay. So a few things. The non-depressed linear skull fracture along the left occipital region extending into the left parietal region inferiorly. What's this mean?
It means a skull fracture, basically a broken skull along the base of the skull.
So here?
Yes.
Okay. What is the
I'm sorry. It's along the base and then up the skull. So it goes from here and up.
okay.
So
And what is this that you're referring to? You talked about the subdermal hematoma.
that would be bleeding inside of the skull.
Bleeding
Bleeding inside of the skull, yes.
Okay. And were you able to tell how many of those different spots of bleeding there were?
Here it says he has a 2 to 3 millimeter acute subdural hematoma and probable mild to moderate hemorrhagic contusions along the frontal lobes. So that's at least 2 places that there's bleeding. There's also a subarachnoid hemorrhage anterior to the right frontal lobe, so that would be a third,
So 3 different spots of bleeding in his brain.
according to the CT examination.
And Now, based on the CT findings and your review of those, what did you determine was the best source of treatment for Mr. Clauser?
Mr. Clauser needed to be seen by a neurosurgeon and in a trauma unit, and so I decided to transfer him to a facility in Columbus, Ohio.
Was that Green Medical Center?
I believe so, yes.
And how was he transported there?
I believe we transported him there by air ambulance.
In an injury such as Mr. Clauser suffered, is death a concern for?
Absolutely.
Are seizures a side effect of a brain injury like Mr. Clauser suffered?
Absolutely can be, yes.
And is memory loss a side effect of a brain injury like Mr. Clauser suffered?
Absolutely can be, yes.
I have no further questions.
Cross.
Thank you, Your Honor. Good morning, Dr. Stiltner.
Good morning.
Dr. Stiltner, I'll refer you to State's Exhibit 2, page 4 of 6.
Yes, sir.
Do you see the alcohol, ethanol, blood result there, the serum alcohol?
I do. It's 265.
What does that mean?
That means that he had alcohol on board in his blood system.
Is that a lot?
It's a good amount, yes. It's not
You-
the highest I've ever seen, but it's definitely a good amount.
Because you had previously said he had somewhat intoxicated.
Yes.
265 would be a lot intoxicated, would it not?
It would be intoxicated, yes. He would be intoxicated, yes.
Would he be highly intoxicated?
Your Honor, I'm going to object. People handle alcohol differently.
Well, I'm going to overrule. It's an observation of the doctor.
In your medical opinion?
There's varying levels of intoxication. As I stated earlier, he appeared intoxicated when he came in. Highly intoxicated is a relative term. Most people that I've seen that are highly intoxicated are incapacitated and not able to usually give me a lot of information. So I would say he was intoxicated. I wouldn't say highly intoxicated. Because he was able to converse with us in a manner that was understandable.
Do you treat people that are intoxicated
I do.
differently than sober people?
Yes, I do.
And how is that?
I'm sorry.
How is that? What do you do differently with someone that comes in with a .265?
Well, someone that comes in with a 265, we generally wait, monitor the patient, but if they're a trauma, then we take excessive steps such as CAT scans, labs, extra treatment just to make sure that we don't miss anything. And in his case, because of the intoxication, we found some things that were concerning, so we transferred him as a trauma.
Now, you mentioned a basal skull fracture.
Yes.
And you can't tell where on a person's head a blow resulting in a basal skull fracture, can you?
I'm not a forensics doctor, so I can only assume that it had to be in the basal area of the skull, since that's where the fractures were.
If I'm hit on the top of the head, can that result in a basal skull fracture?
I guess it's possible, but not, like I said, I'm not a forensics doctor.
Thank you. No further questions.
Redirect.
None, Your Honor.
All right, doctor, thank you. You can step down.
Thank you.
Next witness.
At this time, we would ask to, wait, did he leave that exhibit?
And did he leave the exhibit
Dan.
too?
Yes, he did.
Yeah.
Okay. We would ask to play prior provided testimony of Willie.
Approximately how long is that, do you recall?
I don't know. Oh, Mr. King knows exactly.
Pardon me?
Mr. King knows exactly.
I mean, he knows how to find out.
16 or 17 minutes.
All right, then we'll do that. All right, ladies and gentlemen, the next witness is going to be Willie Hiley. Mr. Hiley has been hospitalized, I believe, since July 22nd for reasons totally unrelated to this case, and is been determined that he's not available. He has testified previously in a prior proceeding in this matter, which was recorded electronically. And so the court's determined that due to that unavailability, you're going to receive his testimony through the plane of the recording of his previous testimony. It's to be regarded and considered the same manner as if he were present here today. All right, Mr. King, are you going to play that for us, please? Thank you.
And Your Honor, I renew my objection.
All right, it's noted and overruled. Yeah. I said we are broadcasting this on YouTube, and I'm not asking if you have an objection to your face being shown on the broadcast. Okay, thank you. Have a seat right over there. Whoa. All right.
See that? Yeah, good. Stop that.
Okay, that's the microphone in front of you. Please keep your voice up and speak loud in your question. Very important.
Good morning, Mr. Wiley. Could you please state your first and last name for the record?
Willie Bentley,
And can you spell your last name?
Highley.
Have you watched any of the video any of the trial on YouTube while you were waiting?
No, I don't have,
I have to ask. And how old is Mr. Wiley?
65.
And you previously served in the military?
Yes.
What rank was that?
Army.
Are you familiar with the Eagles in Greenville?
Yes.
How are you familiar with them?
I'm a member.
How long have you been a member?
20 years.
About how often do you go to the Eagles?
Oh. Once a week, twice a week.
Do you know Lonnie Fowler?
Yes.
Do you know him from seeing him in the Eagles?
Just yes.
What about Ian Miller?
Yes.
Again, do you know him from seeing him in the Eagles?
Some that equals.
Now, were you at the Eagles on December 21st, 22?
Was that when the video was shot?
Yes.
Yeah, okay. I was there.
I'm going to play a video that's previously been admitted as State's Exhibit 1, and I'm going to point to some things and ask you if it's you, okay?
Okay.
Got permission to play the video?
You may.
Mr. Willie, is this you right here?
Yes.
Now, prior to where this video starts, can you tell me, is this Lonnie Fowler in the blue shirt?
I believe so.
And do you know who this is?
I think that's Dan.
Okay, prior to when the three of you are standing here, do you recall where Dan was in the bar?
Well, we was all down this end to start with.
Over here?
Yeah.
Okay. Now,
I don't remember.
Okay, do you recall speaking with speaking with me prior to then?
Speaking with him, but
With me? Do you recall speaking with me?
today,
Before today?
yes.
Okay. Do you remember saying that he didn't threaten you?
I didn't think he did.
Okay. Did you hear Lonnie threaten anyone prior to the defendant pushing him right there?
He was,
I understand he was being obnoxious and hurt. Listen to the
Right.
question. Did you hear him threaten anyone?
I don't know about threatening no one.
Okay. Now, go ahead. Okay, awesome. Now, what are you doing there? You're there with your hands on Lonnie. What are you doing?
I was trying to calm him down,
Okay.
because he was done asked to leave and everything. I was just trying to calm him down so he wouldn't get himself in no more trouble.
He was pretty upset at that point, right?
He flipped his switch here for some reason.
Would you have been upset if Mr. Miller had pushed you like that?
Depends on the circumstances. You know,
Did you need any sort of medical treatment at that point?
I didn't get none, no.
Okay. Did you need the defendant's protection for long?
I didn't think so.
Russ?
Yeah. Yes.
You're a veteran of the United States Army? You're a veteran of the United States Army?
Yes.
And I'll take you back to December 21st,
Yeah.
2022.
Yes.
See if you get there.
A few years,
Do you remember how long you were there?
couple hours.
You trained, when you say 2 years, more than 6, less than 6?
Probably 3 or 4.
What kind?
Just a number like.
Now, you were sitting, if I could directly, I could show you some video, that video of your arm.
Good.
Do you see that? Would you agree with me that Dan
reasoning.
And eventually, were you afraid that he was going to get Dan Miller?
I was just trying to calm him down and see if he'd get out of there before he got himself in more trouble.
It's fair to say that you put yourself between one father and Miller. Is that a fair statement?
Well, that's way for a perk there on that one.
You remember what you're saying to him? You're pointing at the door, or you're pointing over there. You remember what you're saying?
You know, there's a door back there that you go out, and he needs to take it and get out of there before he gets himself in any more trouble.
Talking about this over here?
No. Keep going to your left, or your right. Right there's the main door.
And was it your intention then that you wanted him to leave?
I was going to try to help him leave before he got himself in any more trouble. But he didn't listen to me at all.
Now, you know who this is?
Yes.
Who is that?
Ronnie Years.
How do you know Ronnie?
I've known him since we was real young.
Is it a fair statement that after you got pushed into the chair, Ronnie came to your aid?
I don't know.
Well, you got pushed into the chair, right?
Yeah.
Ronnie came right after that and pushed Lonnie, correct?
Yeah. But I missed that part of it. I was laying down there.
Well, you're watching the video. You're watching the video.
Well, you don't see him up here, but I mean, I missed it.
I'm asking you right now.
Yeah, I'm seeing it now.
And that's you down on the ground, correct?
Yeah.
Or did you see Ronnie throw a punch at him? Did you see his arm extended? Can you see that?
Cut away from here.
See that?
I seen that.
You were all seeing that at the time.
Redirect. Sorry, can I shut down, Mr. Allen? Really, thank you.
All right, ladies and gentlemen, it's now 12 o'clock on the nose, so we're going to recess. It'll be an hour and 15 minutes, so please be back in the jury room by no later than 12:15 so that we can try to start right then. Now, during the break, you have to remember all the instructions I gave at the beginning of the trial this morning, not to discuss the matter in any way with anyone. Don't permit anyone to discuss it in your presence. Don't discuss it among yourselves. Don't do any research about the matter online or in any other manner. Don't read or listen to or post anything about the matter on social media. And don't talk with any of the parties, any of the witnesses that you've heard this morning, or with anyone else about the matter. Be back at 12:15. Thank you.
Please rise.
Your Honor, you said 12:15.
I'm sorry, 1:15. All right, go ahead and leave. I have to stay. We've got to do a Zoom hearing here. You're just going to remain in the courtroom for that, Ms. Collins?
Is the form over here?
Recording in progress. Recording stopped.
Would you, we're ready, Ms. Hapner's not on. The jail's on, but not Ms. Hapner.
Oh, is she on there?
Huh?
Is she on there?
Ms. Hapner's not. Or is she going to be at the jail?
No, she's in Bay County.
All right, well, send her a text. She needs to log in.
Yeah.
Yeah, we're going to do this, Robert Taylor, 23 CR 81. All right, we're on the record, case number 23 CR 81, State of Ohio versus Robert K. Taylor. And you're Robert K. Taylor appearing there from the jail? All right, this is a Zoom proceeding on a polygraph stipulation. Assistant Prosecutor King is in the courtroom on behalf of the state, representing the defendants, Catherine Hapner, appearing by Zoom on her phone. Now, I have been presented, Mr. All right, we're on the record, case number 23 CR 81, State of Ohio versus Robert K. Taylor. And you're Robert K. Taylor appearing there from the jail? All right, this is a Zoom proceeding on a polygraph stipulation. Case number 23 CR 81, State of Ohio versus Robert K. Taylor. And you're Robert K. Taylor appearing there from the jail? Zoom, that may be the problem.